Good afternoon, everyone. Thank you for joining us here in room 25 for what I think is going to be a really invigorating and very timely discussion. I'm William McGivern. I'm the Dean of the University of Minnesota Law School and the William S. Patty Professor of Law here. Thank you for joining us. We're going to hear today from our own Professor Richard Painter and from still our own President Emeritus and Professor of Political Science E. Thomas Sullivan from the University of Vermont. But as most people in this room know, he also is one of my predecessors as the Dean of this law school and also as the Provost of our university. Professor Painter and Sullivan are here to discuss their new book. I'm going to do the Jimmy Kimmel thing now. The U.S. Presidency, Power, Responsibility, and Accountability, which examines the evolving state of presidential power in the United States and is available on Amazon or wherever fine books are sold. It's also going to be available for sale upstairs after this talk. I'll tell you about that in a moment. Professor Richard Painter joined Minnesota Law in 2005 following work as a professor of law at the University of Oregon School of Law and the University of Illinois College of Law. From 2005 to 2007, he served as associate counsel to the president in the White House counsel's office, serving as the chief ethics lawyer. He frequently, and I mean frequently, writes and speaks on government ethics and corporate ethics, and he serves here as the S. Walter Richey Professor of Corporate Law. He's a member of the American Law Institute, and he's a reporter for the new ALI Principles of Government Ethics. He's a board member and vice chair of Citizens for Responsibility and Ethics in Washington, or CREW, as well as a founding board member of Take Back Our Republic, which is a campaign finance reform organization. Tom Sullivan is President Emeritus and Professor of Political Science at the University of Vermont, where he served as the 26th president from 2012 to 2019. He began his career as a member of the faculty of the University of Missouri Law School and Washington University in St. Louis, before serving as the Dean of the University of Arizona Law School. Then in 1995, in the apex of his distinguished career, he became Dean of Minnesota Law. And from 2004 to 2012, he served across the river in Morrill Hall as Senior Vice President for Academic Affairs and Provost for our University of Minnesota. Tom teaches and writes in the areas of antitrust law, and he has served in many, many leadership roles, including as President of the American Bar Foundation Board of Directors, Chair of the ABA, and Chair of the ABA section on legal education. In 2015, President Sullivan received the ABA's Robert J. Kutak Award for his contributions to the legal academy, the judiciary, and the bar. So it is really a cause for celebration for me when two titans of Minnesota law come together and bring us such a relevant and incredibly timely book. In the U.S. presidency, Sullivan and Painter examine the evolving state of presidential power in the U.S., specifically facilitating discussion and debate about the power, responsibility, and accountability of U.S. presidents, as their subtitle says. The power, responsibility, and the accountability. Rather than promote any single theory, they're answering questions with a wide range of arguments for and against power in a broad number of circumstances, looking at policy and law, political science and politics, the past and the present, and to some degree, the future. It's grounded in that intersection of law, politics, and history, and goes across disciplines in a way that expands understanding. So questions of presidential power, accountability, power, responsibility, and accountability are obviously on the front page every day right now, as well as in courts across the country, and especially actually right here in Minnesota at this point. When the boundaries of executive authority are being tested, unlike ever before, we're lucky to have the two of you here to join us and share your insight. So before we begin, a few administrative notes. Today's event is being recorded. Following the discussion here, we're going to open up to your questions in the last part of our time together. After the program, I hope you will join us upstairs in Auerbach Commons. Unfortunately, we're not doing this in Sullivan Commons, which is named for Tom, where his portrait hangs just around the corner where the cafe is. But Auerbach Commons was bigger, so we're going to do it there. So it's just up the stairs for light refreshments. And at that reception, copies of the book will be available for purchase. So now please join me in welcoming President Sullivan and Professor Painter. Good.
Thank you, Dean, for those wonderful introductory comments, and welcome all for being here. Leslie and I are delighted to be back in Twin Cities, and particularly here at the U, and especially here in Mondale Hall at the law school. We are, as the Dean said, happy to be here because we want to talk about one of the most important, we hope, timely, we hope, relevant, we hope, topics in our country today. And as you can see, the book is entitled The U.S. Presidency, Power, Responsibility, and Accountability under Article 2 of the United States Constitution. I'm going to spend just a few minutes here in the beginning to share with you the kind of the arc or the development and the evolution of this book. We got the contract to write the book from Cambridge University Press in October of 2023. Richard and I did not ever conceive of a second Trump presidency at that time. We want to make clear that this was not a Trump book. Things happen. We had an election, and we now are, of course, in the second Trump presidency. We turned the manuscript over to Cambridge University Press in the last week of January, 10 days, 25 days after President Trump was inaugurated the second time. And we got back in June of 25 the page proofs or galleys for technical correction. Well, as you all know, a lot happened in those days, those 25 days. I can't tell you now the number of executive orders that were issued, but Cambridge was let us do much more editing than we normally would have done. And I think Richard and I probably wrote 50 to 70 new pages or had to alter by reason of those executive orders and many federal court injunctions that were issued. So I want to talk about what this book is really about and kind of the takeaway points for you so that you don't have to go out and buy the book if you don't want to. But I want to write here at the introduction, if he's with us, Philip Mellon. Philip is a graduate of the class of 2020. Philip, would you please stand? Our research assistant for this 3-year effort, graduate of this law school in 24, now over at the Carlson School getting another, in this case, a master's. Thank you, Philip. And I should recognize many other research assistants here as well. Well, the book is in 3 parts. Part 1 is power. Where under Article 1 does the president get power, and how does he or she get that power? Part 2 is responsibility. What does the Constitution say about the responsibilities and the requirements that a president undertake? And part 3, of course, is accountability. And I think Richard and I will talk perhaps a bit more about that in greater detail, the section on accountability this afternoon. The book, as the Dean said, is really framed around the history and the politics and law and how they interrelate and how politics affects lawmaking and how all of that comes and has to be interpreted in the context of our living society, and some of us believe in our living Constitution. The lens that one can look through as we tried to analyze this material from the Revolutionary War to President Trump 2 is first, what did the founders think? What was their intention? What were the debates and the written statements and the Federalist Papers, et cetera? And quite frankly, those of us who have studied the Constitution in any length know that you can, a term we don't use in the book, but I will today, cherry pick what you want to find in that history. So we decided we wanted, and I hope this was part of what the Dean said, try to come up with a balanced approach that looked at the weight, a lawyer term of course, the weight of the evidence and how persuasive that was in light of all of the very contentious debates that took place, but ultimately came to a unified resolution in the adoption. So the founders, their intent. Now you all know today in history and the currency of the times that originalism is a big deal. So this is part of that originalist approach. but we tried to find the weight of the most persuasive evidence to deduce what we think the founders, and we talk about that. Second, what has the Supreme Court said since the court came into being with regard to Article 2? So we've covered virtually all of the important cases in this book. And third, what has the academic critique, the academic scholars said about this Article 2 power, responsibility, and accountability? So the reader gets to see the founding understandings, the interpretations, and the critique. And then we ask you through this, what we hope is public scholarship for a wide audience. You can decide for yourself after you've read and engaged the material. So that's the frame, the intersection of law, politics, and history through what the founders thought, the courts have interpreted, and the academic critical critique. Now, point number one, first principle of the founders. The first principles of the founders, and you probably haven't heard this or read this, but it's absolutely clear. The Congress was to predominate over the presidency. There's no question about that. Hamilton wrote it, Madison wrote it. There was no question. Why? Because we just fought a Revolutionary War over a tyrannical, dictatorial King George III and Parliament. They did not want to repeat that in any way. Yes, it is true that Hamilton wrote, we need a strong and energetic president, because the Articles of Confederation were a complete abject failure. They didn't have a judiciary, they didn't have an executive branch, they had no taxing power, they had no commerce power. It was a federation of the 13 colonies with no unified goals or aspirations together. And so the founders were clear, strong, energetic, particularly in emergency situations for obvious reasons. But we need to have those checks and balances, the separation of powers, so that the Congress would make law and the president was there to implement and execute the laws. A bit of a change from some thinking today. So the separation of powers becomes a very important underlying core, fundamental, foundational concept throughout all of our history. And these theories combine together. Strong president in one person. There was great debate for a long time about, well, let's have a committee. Well, you know about how that accountability goes. They wanted one person for accountability purposes. And hence we have the one president under Article 2. But then it was all about checks and balances, separation of powers, democratic accountability. Declaration of Independence starts, we the people. U.S. Constitution starts, we the people. But people are the sovereigns. And we have this indirect constitutional republic democracy where we send representatives to school boards and state houses, state legislatures, and the federal government to represent. But ultimately, it's the people who are supposed to decide, ultimately. And the framers were very clear about the importance of this. They were well educated. Over half of them, of the founders, went to college and had college degrees. Many had legal training, mostly reading law at that time. Very smart for their time. But they wanted to make sure we did not repeat a dictatorial, tyrannical Article 2 presidency. That was very, very clear. So the book goes through the history of that, and we conclude also with those same principles. And so in summary, in this introduction, I want to come back to what are those fundamental principles that the founders were completely in agreement. At the end, not throughout the debates, there was great vigorous debates. And those were the importance of separation of powers, these checking mechanisms as functions between the Congress and the presidency, ultimately, but they certainly never envisioned the judicial review that our Supreme Court ordained in 1803. But nevertheless, among the three branches, checks and balances back and forth, so that we didn't get so much overreach in power and perhaps abuse of power. So what did they leave us with? They left us with the importance of checks and balances, due process of law, democratic accountability. Fundamental from the beginning of the debates to the adoption of the Constitution in 1789 throughout history. And you can see the book is really about this huge transformation of power from the Congress to the presidency. And we believe, I think we're all living in a state where this president and the presidency over time has clearly dominated leadership in this country, and fewer checks, as we see in our polarization today, by inaction or acquiescence by our Congress. Something I think the founders just simply couldn't believe today if they were here to look back. And so now Richard and I are going to go through each 2 or 3 of these major question issues today. We've picked a couple of pretty current ones, I think, that you're probably interested in. And then the dean, and we'll open it up for your Q&A thereafter. Thank you. Richard?
Tom, I'm going to start the conversation with the President's role as Commander-in-Chief. And the first question, can the President alone decide whether this country goes to war? And this is an issue which may come up again in the next 12 weeks to 10 days with respect to Iran. But it's come up many times before in our history. But the perception of presidential powers in this area going to war has expanded dramatically. We see in the book, we tell the story in our book, from the time of the founding until today. In the 1890s, the Adams administration was dealing with a very hostile relationship with France. The Federalists, of course, were much closer to the British. The Democrats, of course, the French. But the Federalists were, I did not turn my, there we go.
Oh, much better.
The Federalists in the Adams administration were very angry that the French would not allow our ships to trade with the British and would attack our ships. So the question was, what could we do in response? What could the president do? What could President Adams do? And when did he have to go to Congress? And indeed, Alexander Hamilton, who among the founders was one of the strongest advocates for presidential power, wrote numerous letters to other officials in the administration explaining there's only so far that President Adams could go. We could, of course, defend our own ships. And if there was hostility toward us, we could attack their ships. But the idea of going and launching an attack on a French colony or something like that, no, you have to go to Congress. There's only so far that the president can go. And this is the Federalist Party, which believed in more presidential power, certainly than the Jeffersonian Democrats. A very different world than that we live in today, in which it is considered an open question of whether the president could order the bombing of Iran, which happened last year, it may happen in a week, or whether President Clinton in 1998-9, yes, with NATO support, but not with the support of the United States Congress or the United Nations Security Council, could bomb in Yugoslavia. We've seen many examples of use of presidential power to go to war without the consent of Congress, despite the War Powers Act of 1974, which was supposed to address this issue after the catastrophe of Vietnam. And so this is an issue we're continuing to discuss in our society as we may get dragged into yet more wars at the prerogative of one man, and that is not, we don't perceive in our book here, looking at the history of what the founders intended. Now consider also the Alien and Sedition Acts of 1898 and 9. They were intended to deal with seditious immigrants. Of course, not only did you have to fear the French taking your ships, but the French might send revolutionaries with anti-American ideas over here. And what are you going to do about them? And deportation of immigrants with undesirable ideas, immigrants who were perceived as a threat. Clearly, First Amendment issues were there at stake with the Alien Sedition Acts. Thomas Jefferson felt very strongly that the Alien Sedition Acts of 1898, that the 1798, that the Alien Sedition...
On the third go, I had to jump in.
Yeah, thank you very much. 1798, he said this is terrible. Now, the Supreme Court never ruled on the matter. President Jefferson won the 1800 election. I always think of 1800, that's when he won that election. It was the first peaceful transition of power, by the way. President Adams lost, and he went peacefully. He didn't do the January 6th routine. And President Jefferson then repealed the Alien Sedition Acts of 1798. But to this day, we continue to debate whether those laws are constitutional, and some of them are still on the books and being invoked by the Trump administration today. Is this constitutional? Is it not? The jurisprudence in the First Amendment has clearly evolved over time since the founding, and if the Supreme Court would adhere to its current interpretation of the First Amendment, I would think that some of what the administration is doing, for example, deporting aliens based on the content of their speech, could very well be unconstitutional, even if the Sedition Acts purported to allow such a thing. And then with respect to presidential authority, with respect to the military, can Congress restrict the president from deploying the military inside the United States for domestic law enforcement purposes? Congress did just that after the Civil War in the Posse Comitatus Act. And this was part of a compromise to get the military out of the South. And it was a very problematic compromise, of course, we know from that history of that time period of Reconstruction. But the point is that Congress decided that the military was not there to be a domestic police force. And it's prohibited, subject to certain exceptions. And of course, what we've seen is President Trump aggressively use the exceptions. First, with respect to the National Guard, Title 10 statute allows the president to use the National Guard for certain specific purposes. President Trump said they were merely protecting federal buildings and protecting ICE officers and so forth. He had a very disappointing opinion from his perspective, not from mine, from the Supreme Court, which said, no, that's not the correct interpretation of Title 10. So then President Trump pivots toward another statute, the Insurrection Act. And this, of course, was very much in our minds and maybe keeping us awake at night here in Minnesota only a few weeks ago when Trump, the president, repeatedly threatened to invoke the Insurrection Act in Minnesota. Now, you could read the statutory language. We could tell from the statute's name that to invoke the Insurrection Act, there should be an insurrection. And I don't think that people protesting ICE and maybe some people, a few renegades throwing snowballs at the offices, that's not an insurrection. But anyway, that danger may have passed for the short term here in Minnesota, but is very much alive and well 2 or 3 weeks ago. And every time someone started talking about insurrections and civil wars in Minnesota, I got visibly upset. Even upset at Governor Walz for even making a reference to Fort Sumter in some off-cuff remark, because there's certainly no insurrection here because we opposed lawfully. We opposed the, I think, illegal conduct of the ICE officers in Minnesota. There's so many issues with presidential war powers and commander-in-chief. I certainly dealt with them in the Bush administration, telling people that I strongly disapproved of the interrogation methods used in the torture program. And yet John Yoo wrote a classified memo, he was from the Office of Legal Counsel, saying that Article 2 of the Constitution is so important that it takes precedence over the torture statute, which is a criminal statute, and also the treaties the Convention Against Torture. Oh, forget the Supremacy Clause, which says that the laws, the Constitution, and the treaties of the United States are the supreme law of the land. We dealt with Commander-in-Chief powers in many ways in this book. I've only mentioned a few. The Take Care Clause. The president has an obligation to take care that the laws are faithfully executed. There are many scenarios we discuss in this book, ethics. Maybe the president should adhere to the Emoluments Clause of the Constitution, which prohibits anyone holding a position of trust with the United States government from receiving any gifts, titles, or emoluments, profits, and benefits from foreign governments. Well, every president has taken care that at least that provision is faithfully executed until 2017. Happy to discuss that. But how about the question of whether the President of the United States is bound to obey a Supreme Court order? We would think that this is not a matter of debate, that this was settled in Marbury versus Madison, 1803. Am I getting my dates correct?
Yes, you're right.
You got the right century this time, Richard.
Century this time. And I would think this would be settled. That, I know it's not there in the Constitution, exactly those words, but the Chief Justice Marshall established that the courts will decide what the law is, and that Congress and the president can't just overrule the Supreme Court. If Congress passed the Judiciary Act and a provision there giving the Supreme Court original jurisdiction is unconstitutional, it's unconstitutional, end of discussion. If President Jefferson thinks that he can just not deliver a commission to Mr. Marbury, signed by President Adams because he doesn't feel like delivering it, well, no, that's a valid commission. He gets his commission. The Supreme Court made that very clear, that the courts decide. We've had one president, we identified in this book, who disobeyed a Supreme Court order, is President Andrew Jackson in it was a Worcester case with a missionary down in Georgia who was actually trying to help the Native Americans, the Cherokee. And it was a complex case, but bottom line is the Supreme Court came down and saying the state of Georgia was infringing not only on the plaintiff's rights, but the sovereignty of the Indian nation, of this Cherokee nation. And President Jackson said, well, Chief Justice Marshall's written his opinion, now let him enforce it. Well, he's the only president. Now, there's a talk that Abraham Lincoln did. He did not disobey a Supreme Court order. Justice Taney, sitting by designation as a district court judge, did tell President Lincoln that he could not suspend habeas corpus without the permission of Congress. I think Chief Justice Taney was right on that, probably the only thing he was right on. He's one of the worst Chief Justices in American history. Dred Scott and all that. Still, President Jackson is the only president to disobey a Supreme Court order. And yet now we have that conversation where the Vice President of the United States has said that the president need not follow a Supreme Court order. I think this is very dangerous. And by the way, I pointed out 2 years ago when some liberal law professors, one from Harvard, one from Yale, they're going to come up with great ideas, right? They said the President Biden should disobey Supreme Court orders and put it in some liberal newspaper. And I said, this is crazy. The President of the United States has to obey Supreme Court orders. That's part of taking care that laws are faithfully executed. I guess I've said enough.
Well, picking up from there, we want to turn our attention to the part 3 of the book, which is the accountability section, and I just picked a couple out on accountability. I referenced a moment ago, we the people, and the Declaration and the Constitution underscore that. The people are the sovereigns. So when we come to accountability, we think of us. The ballot box. If the status quo is not acceptable and we need change, we have midterm elections coming up in 8 months, presidential election in 28. The ballot box is the best signal for whether we approve or we don't approve. That is a major accountability element within the Constitution. Congressional oversight. I talked about that a bit in my introductory remarks. Very important. Congress legislates, and they also have the power of oversight hearings. We've seen in many of those. At the moment, and perhaps in more recent administrations, we've seen those oversight hearings really being used as a political weapon, as opposed to genuinely trying to figure out whether we need to enact new laws or modify laws. Oversight. We see now in Congress a lot of, as I mentioned earlier, inaction or acquiescence in presidential behavior. This is a very important check in the accountability realm of a president for the Congress to do oversight and to legislate to make sure there isn't overreach or an abuse of power by those in Article 2, the executive branch. This is an opportunity in terms of accountability for the legislature to reconsider their institutional congressional role under Article 1. They have very specific constitutional responsibilities to legislate and also to oversee the rest of the government, particularly Article 2 in this case. They would probably like to oversee Article 3 judges as well, but thank heavens they have life tenure, Jim. So an opportunity for the legislature to reimagine and reconsider and re-embrace their constitutional responsibility of oversight. And here I want to mention also the third category, and importantly, our federal courts. Our federal district courts are so very important, and perhaps today more than ever. If there are guardrails left, right now it's in our federal district courts. These are the judges who are appointed by the president, Senate confirmation, and what they do that we sometimes forget, they are the finders of fact in hearings and trials and draw conclusions from those facts. And there's an appellate rule that sometimes we're forgetting in this country, which says that an appellate court cannot reverse a district court opinion unless it is arbitrary and capricious. And today we think there are many appellate courts, and sometimes our Supreme Court, who are ignoring the actual findings of facts by the trial court judges. And the trial court judges not only make findings of fact, but importantly, are the judge of the credibility of the witnesses before them. Appellate courts don't do that. They don't have that record in front of them, nor the Supreme Court. So I think that other accountability is the importance of our federal district courts as the guardians of those findings of fact and conclusions of law that should not be set aside unless clearly erroneous and capricious. So that's at the federal level. People, the ballot box, oversight, legislation by Congress, and judicial review by our federal courts. But I also want to turn to our state governments, because we are a country embedded in the Constitution, this doctrine of federalism. And some examples that have been in front of us in the last couple of years: the Georgia criminal case indictment against President Trump, the New York criminal case where President Trump was found criminally guilty as a felon, the New York case, the civil case where we found, a jury found that the books of the family business were being altered, and many of them false by reason of, and of course that led to the civil case about the interference with the election by reason of a payoff, so that the embarrassment of that payoff 3 weeks before the election would not interfere the election in 2026, Hillary Clinton, Donald Trump. So you have the whole federalism concept of state courts and state legislators. And we have also forgotten, and I think many liberals or progressives have forgotten over the years, this doctrine of federalism and the 10th Amendment. The 10th Amendment to the United States, the last of the Bill of Rights, says this: if not given to the federal government, the right, the power, if not taken away or from the state government, that power is vested and flows to the state and to its people. Very important 10th Amendment. How does that apply here? It applies here because when you have this duality of judiciaries, federal laws and state laws, there's a lot of accountability that can also take place at the state level. For example, our states, and through their elected officials, the district attorneys, can hold grand juries to account for federal actions. 10th Amendment. Indictments can be brought, we believe, under the 10th Amendment and under this important constitutional doctrine of federalism for federal officials to be indicted and to be tried in courts. And the other side may say, well, we've got the Supremacy Clause you mentioned a moment ago. We got preemption you mentioned a moment ago. But we can go back then to the 10th Amendment, where that vesting and that power goes to the state government. The legislature to be able to enact legislation, elected district attorneys to convene grand juries, to hold criminal trials. And I also should say with accountability, because of Supreme Court opinions, back on the federal level for a minute, you cannot sue a sitting president for damages, money damages. The rationale, of course, is he's too busy, he can't take time out for all these trial times. Except in the Clinton case.
That's for personal conduct.
Yes, this is personal conduct. In the Clinton case, it was Justice Stevens who said, well, no, wait a minute. Wait a minute. These people, and Scalia joined him in this.
Yeah.
Some of these justices are out, or presidents are out playing golf, and they probably can take time to sit for a deposition and so forth. So there is that, but the court has said for personal conduct only can you sue the president. If it's in his or her official capacity for damages, you cannot sue him because of this defense. However, you can sue the president for injunctive relief, and that's why we're seeing all of these over 200, 300 lawsuits now filed against the Trump administration for injunctive relief. Stop the behavior because it's overreaching, it's unconstitutional, violates statute or whatever. I wanted to make clear the difference between state court action, federal court action, when presidents are immune, and of course that leads us to the immunity decision. Richard, if you want to comment on that for a minute, in 2024, where the Chief Justice and the majority of the court said that presidents are immune from indictment and from trial while they're sitting in office for official presidential conduct rather than personal conduct.
Even after they leave, you can't indict a president for his official acts because there's a strong presumption of immunity, absolute immunity, if it was an official act within his core constitutional powers. Of course, the court didn't define what the core constitutional powers are. I think it's one of the worst decisions in Supreme Court history, Trump versus the United States, establishing that there's so much immunity for the president in his official acts, even from criminal prosecution. I mean, I understand Nixon v. Fitzgerald, where the Supreme Court said you can't sue President Nixon for having fired you unjustifiably for money damages. Okay, but to say that the president can't be criminally prosecuted for committing a crime in office in his official capacity, all I can say is that's not the law in South Korea, where a president is apparently going to be serving something close to a life sentence for declaring martial law in a situation where we have no right to declare martial law. I think it's a very dangerous decision, Trump versus the United States.
And talking about that decision, we think the court in the immunity decision, Trump versus United States 24, did not give sufficient weight or credibility to a very important decision. I actually disagree with it, but it's bedrock law, and that's Youngstown Steel. President Truman, Korean War is the context. The steel industry was about to go on strike, union difficulties and so forth. And Truman decided that to be able to sustain the Korean War, he needed to have the government seize the steel industries because we needed the steel for the war. And that went up to the Supreme Court, the case is Youngstown Steel. And the concurring opinion, where one of the rare times when the concurring opinion really becomes the precedent, Justice Jackson said three things. And we think that this still should be the test because it seems so balanced and so reasonable and without political implication. One is, has Congress spoken favorably on what the president's conduct is? If so, the president is at his highest power. Category number two, is Congress silent? They haven't spoken one way or the other. If that's the case, the president only has his specific enumerated powers under Article 2. So you go to Article 2, see the list. Or number three, if Congress has shown its distaste or dissatisfaction with the president's action, the president is at his lowest ebb in terms of power. That's the way the case came out in this case against Truman. But we think that is really still bedrock, black letter constitutional principles that stand the test of time even today. The court rather brushed that aside. They did cite it, brushed it aside. But that balancing of where you're at your strength when Congress gives you the nod, or when Congress is silent, then your powers are less, or when Congress says no, you don't have the power. That's a very objective, not subjective kind of approach. Yeah. I'd like to just end, Dean, with a couple of other very quick accountability measures that are in the current discussion today. The president has the power to pardon. Pretty clear, absolute sentence in the Constitution. The question is, can the president pardon himself? And we have seen discussions or heard discussions recently about that. If you take the English common law, which the founders looked at, the colonial knew and realized it, and embraced it in their debates, it is clear from the English common law that there was a consideration of a bilateral contract. Two people involved, not one. One comes to the king and asks for repentance, forgiveness, charity, whatever it was. And it was a bilateral agreement, implicit that you conceded and that you had this problem, this harm.
Andrew's going to try.
Yes, and then the king would either grant or deny. A bilateral agreement understanding. We could have seen that perhaps in the Nixon-Ford agreement. There is some history there, we believe, where back and forth, probably not between the presidents, but the White House, of when Nixon resigned, Jerry Ford gives the pardon, and you remember that was highly controversial at the time. I remember being very upset by that as a young lawyer in 1974, coming out of a federal clerkship. But over time, it became clear to me that Jerry Ford was right. His defense, let's get this over. Let's get behind this. We don't want to spend 2 or 3 years, he's probably thinking of his administration, litigating this thing in the courts. But today it becomes, again, relevant. I think Jerry Ford and I think Richard Nixon believed that it was a bilateral understanding. It was not unilateral without a tacit agreement between and among them and their staff. Today, the answer is not clear. The Supreme Court has not spoken on that issue. However, maybe it's an irrelevant question, because under the immunity decision that Richard just spoke of, the president has the constitutional right to pardon. Therefore, and he has constitutional right to run the entire third branch of government, second branch of government. So he can merely tell his attorney general, dismiss the indictment. He doesn't have to self-pardon. But there are 2 reasons why that would be imprudent, and maybe he needs to try the self-pardon, and then, of course, we litigate it. One, his successor, who may be of a different party, may come in and have his attorney general indict him, in which case you don't carry the pardon power over. Or second, and very importantly, the president has no power, no constitutional right to pardon for state crimes. Hence the New York criminal or the Georgia or any of those cases that were or might have been. It does not apply to state action. And hence back to the concept of federalism and the power of state officials to try to have oversight over federal misconduct as well. And finally, just a quick note about the upcoming election in 2028. There's some talk that President Trump may decide he'd like to stay in the White House. I think the 22nd Amendment is absolutely clear. It says no person can be elected twice, more than twice, to be president. The defense that I've heard by the White House and other speculation is, well, that doesn't apply to me, President Trump, because I was a non-consecutive president. That only applies to consecutive presidents, so it doesn't apply. Well, actually, that's wrong because there's only been one non-consecutive president before President Trump, now two, and that was Grover Cleveland in the late 1890s. President lost, came back, won. So when we passed that 22nd Amendment in 1952, that legislative history was absolutely clear. Everybody knew about the non-consecutive Grover Cleveland, and that's why the sentence is so clear. Elected no more than twice, period. I don't think we have to worry about it. Bill, thank you.
Well, thank you both. That was quite a whirlwind tour through a number of important issues. So I want to open it up pretty soon to our audience members for questions. I'm sure there may be a number, and there are going to be folks walking around with a microphone. So if you do want to ask a question when we get to that point, I'd ask you to indicate, and they'll come to you with a microphone. But I'll just sort of prime the pump with a couple of questions of my own. So one is something that comes up a good amount in the book is the concept of an emergency and how that has been an important inflection point for a lot of the expansions of presidential power that you point to throughout history. So what is it about the emergency that's particularly dangerous? And of course, this is very current because just last week, the US Supreme Court rendered the decision on tariffs, which suggested that President Trump was improperly using an emergency power that had been granted by Congress. That's one time an emergency was not able to be invoked, but where are some times when emergencies have been responsible for big expansions?
We've had this since the beginning of the Republic. Said with that situation in the 1790s with the hostilities with the French. Then we ended up in a war with the British in 1812. But the point is always an emergency, and that's why they had the Alien Sedition Act. We got an emergency going on. All these French revolutionaries are cutting everyone's head off over there. They're going to come over here and cause chaos. So there's an emergency. Then you had a real emergency in the Civil War where President Lincoln did suspend habeas corpus. I think he was wrong on that. He should have gone to Congress. The problem is they couldn't get Congress down to Washington. Why? Because the rebels were blowing up the railroads up in Maryland, and that's where he suspended the habeas corpus. But there's certainly a dramatic expansion of presidential power under President Lincoln. Perhaps necessary, but the Emancipation Proclamation itself was an executive order, as we discussed in the book. Before, of course, we adopted the 13th Amendment banning slavery. Then we had more emergencies in World War I. I mentioned the Red Scare after World War I, but the whole period in World War I and the aftermath led to quite a few people being arrested simply for exercising their freedom of speech. Whether it's opposing the war or people who were perceived to be communists, and the Red Scare and the Palmer raids, where the Attorney General, this sounds familiar, the Attorney General is ordering federal agents to go round up immigrants. Then we, of course, have World War II, an emergency, the Japanese bomb us in 1941. And so in 1942, President Roosevelt orders the internment of Japanese Americans. American citizens of Japanese ancestry, with the collaboration and support of the Attorney General and later Governor of California, Earl Warren, who later became a Chief Justice of the U.S. Supreme Court, and who was later on in his life said he was ashamed of that decision. But the Korematsu opinion, the Supreme Court upheld presidential power in that area. And then, of course, after 9/11. What we saw with not only the Patriot Act, but I mentioned before, the torture memos and so forth. So there's always an emergency. Sometimes it's a real emergency, like 9/11 or the American Civil War, and sometimes it's an emergency made up by the president because he's sitting there watching. I guess he doesn't watch Fox News anymore. Maybe it's Newsmax or something else. But the question is, who gets to decide whether it's an emergency? And same with an insurrection. And if people are calling what's happened in Minnesota a couple of weeks ago an insurrection or a civil war, I mean, they weren't here in Minnesota. And should one man be able to make that decision? So this is part of our history, is emergencies, real and perceived, being used to expand presidential power.
Bill, your question is a very good one, and I think what Richard is alluding to is that we need to have much greater clarity on what is a national emergency, what is national security. Congress has tried over the years to do that, hasn't been successful, certainly hasn't been paid attention to. But this is where we need a Congress oversight, Congress's responsibility, because Article 1 says Congress is the only one that can make a war, declare war. And so we need greater clarity from Congress, or perhaps an amendment to the Constitution on what really is a trigger national security or national emergency, rather than subjective ad hoc context.
Sure. Well, the other question I wanted to ask that emerges, I think, very clearly from the book is the question of sort of self-restraint by the executive branch. So, Tom, you went through a long list of different kind of formal mechanisms: elections, legislation, congressional oversight, judicial opinions, state action. And those were all kind of governmental mechanisms that are available to potentially check expansions of executive power. But you also talk in the book about times when that didn't happen and the executives themselves chose not to expand power. So
Right.
what are some instances of that happening that you'd see as perhaps success stories around sort of stopping this inexorable expansion that you otherwise are charting?
It's your question, Bill, raises this intersection, this juxtaposition of power and responsibility and prudent judgment.
Sure.
I may have the power, but ought I to exercise the power and take that responsibility? I would think a couple of instances, Richard, you add as well. The Cuban Missile Crisis. I think Kennedy held back the barricades and all of that rather than nuclear weapons, Khrushchev, all of that, very intense 10 days or so. There was a refrain there. There was a calmingness to the decision-making process, and ultimately it came out very successful. So I think that's where the foot came off the pedal. Let's think about this. And the ambassador of the United Nations at the time, Adlai Stevenson, I think was the one who really came down with the answer to that. So that's one example of refrain that was very prudent.
And something that could have been an emergency, but that was
And
instead
could have
characterized
ended
differently.
very badly
Right.
because of the talk of nuclear submarines and so forth. Richard?
Yeah, I think it depends on the area of presidential power. With respect to war, as I mentioned, the Adams administration, as much as they were in love with presidential power, was cautious about what they could do in opposing the French without going to Congress, much more so than recent presidents of both political parties, who seem to really think they can go and start hostilities wherever they want in the world. And it's just Congress's role is to just simply declare war after the president starts a war. That's not the way the founders saw it, and that the Adams administration showed restraint. Much more recently, I think Jimmy Carter, after the Nixon presidency, when he reformed the Justice Department, and actually the Ford presidency, they also reformed the Justice Department. So during the Ford and Carter years, there was a determination on the part of the White House to make sure we had an independent Justice Department. There's nothing like a mugshot of the Attorney General, Big John Mitchell there, to send the message that maybe we need a politically independent Justice Department. Unfortunately, there's been a lot of retreat from that under both Democratic and Republican administrations since then, but there's a lot of restraint there. We have had presidents who've exercised restraint. Financial conflicts of interest to the president. Not since the Civil War have we had a president with substantial financial conflicts of interest with their own family businesses. And yes, I have been asked, is Donald Trump the only one in American history? No, Jefferson and Washington visited their plantations. I had a congressman ask me, do you think that they were unethical for going back to Monticello and to Mount Vernon? And I said, well, yeah, I think there's slave labor on the plantations. I mean, look, our founders can be, wrong in some things. And those financial conflicts of interest of early presidents, senators, and members of the United States Supreme Court were very tragic in our history and led to the perpetuation of the slavery issue through the Civil War. So financial conflicts of interest, many presidents have shown restraint, but our early presidents did not, with tragic consequences. And President Trump, well, don't get me going there, I'll be going on.
Nope. We've seen you on the TV talking about that.
Well, one more current example that I think we forget about, George H. Bush, the Gulf War, went in very strategically with a goal. As soon as it was accomplished, he pulled everything out. He refrained. He got criticized later by perhaps his son's own administration for not finishing the deal. But he believed in the Powell doctrine. You go in with strategy, you're very precise, you've got the tactics, you get in, you get out, you have an exit strategy, and you know that before you come back. And I think George H. is one of the most underrated presidents, quite frankly, we've had. Very practical president, but one who's well-grounded, extremely experienced going into the presidency. And that judgment of restraint probably saved us a huge war at the time.
Okay. Well, I have more questions. I'm happy to ask them, but I do want to turn over to our audience members who might have some questions. I see Professor Werman in the front. I see a hand in the back. So let's go directly to what I expect might be a provocative question from Professor Alam Werman.
So I have about a dozen questions, but I'll reserve myself to two.
All right,
one
two.
has parts A and B, though, but they'll be short. First, super short question. Eric Nelson has this book that he calls The Royalist Revolution, where he argues that actually the American Revolution supported sort of King George III. I have an answer to this, but it seemed very inconsistent with what you were saying about Congress predominating. I'm just wondering if you've grappled with it. It could be one of those situations where his title is just catchy, but what he actually says doesn't quite meet that title. So just what do you make of that, if anything? And then under the OLC legal framework for military conflicts today, right, that not all military actions are war within the constitutional sense, depending on the nature, duration, and scope of the armed conflict. This is what justified going into Libya or bombing Libya. Under your understanding of that test, would that have justified the capture of Maduro? And how does that compare sort of to the original meaning of the Constitution, original distribution of war powers? And then isn't that sort of Youngstown Category 2, the Venezuela capture? And if so, like, doesn't Youngstown Category 2 invite presidential prerogativism, right? If the president, contemporary imponderables, imperatives of events can invite presidential action in the face of congressional silence, and isn't that dangerous? So you celebrate the Youngstown framework, but isn't that opinion unjustly celebrated sometimes?
Let me have Richard take the one question, and I'll answer the first and the third. I don't agree with the theory of the book. As I mentioned earlier in my introduction, we've tried to go through and find the weight of the evidence, the persuasive evidence, not the needle in the haystack. I think that answers his thesis. On your second question on Youngstown Steel, I think that second category, when the Congress has been silent and that neither disapproving or approving, the court was suggesting you have to go to the precise, exact, enumerated powers under Article 2 of what the president has. And in this case, it would be obviously commander-in-chief, right? And then go and look, as Justice Frankfurter tells us, in the concurring opinion, look and see what the practices and precedents have been in handling that situation. Richard, do you want to take the
based on my reading of the history of the Revolution, I don't think King George III was too popular. Just read the Declaration of Independence. So, I mean, there may have been some people who thought, gee, it's all about Parliament, and we don't like Parliament because, yeah, they're all corrupt. They're bought by the East India Company. That's true. But that King George would be our salvation. That's not at least the way a lot of the founders talked, and the Declaration of Independence doesn't talk that way. I think there's a real desire not to have another King George III. who, by the way, would have been 25th Amendment eligible. He went mad and all that for removal. I just look at the weight of the evidence. I mean, you'd always cherry pick in the founding and have someone who really likes the king but not Parliament, but I'm not sure that's there. Venezuela, do you go in there and exercise an arrest warrant on a foreign leader in another country? Using the military without a declaration of war, I think you're running into serious trouble under both the War Powers Act and, of course, international law issues that arise with that. And all I can say is some other country tried that with us. Well, it might end differently, but that's just because we've got more firepower than they do. I'm not sure that's the road that we want to go down and encourage other countries to do. Restraint in the war powers area, I think, is critically important, and the Congress needs to revisit this. We did after Vietnam with the War Powers Act, but apparently the way it's being interpreted is we can bomb first and then 48 hours tell Congress why we bombed somebody. Well, I get back to why put in the constitutional provision, it says Congress declares war if the president can go start a war. I think the founders weren't stupid. If they wanted the president to be able to do that, they would have given them that power.
And just to be a bit fair to the king, when George Washington announced he was not going to run after a second term, which would have been legal at the time, King George III said his giving up his presidency and giving up his generalship, after which he resigned and surprised me, that is real leadership. Mm-hmm. Leaving when you have the prudence and judgment to know when.
Yeah.
So we have to give the king some judgment credit, even though otherwise a bad dude.
And another example of self-restraint.
Yeah, exactly.
In the presidency.
And a point on George Washington. One of the reasons we have Article 2 written the way we do is because most of those founders, if not all, assumed that he would be their first president. They knew him as a colleague and as a founder. They knew him as the general who won the wars, kind of surprisingly, but nevertheless had great respect for this humble, modest man. That was their model of a president. Yes, they were very concerned of tyrannical dictator, but that wasn't George, and that wasn't going to be our president.
Okay.
So that was very important to understanding his power and overreach question today.
So I'll ask one quick follow-up to you, Richard. Is the killing of Osama bin Laden any different because of the authorization of the use of military force or any other reason, or do you have similar concerns?
Certainly the authorization of the use of military force from 2001 would have authorized an operation killing Osama bin Laden, who planned the terrorist attacks in the United States. Mm-hmm. Now, this was an operation conducted in Pakistan, so you had international law issues and questions about how much the Pakistani, of course the Pakistani government was not going to say, come on in and do this, we're going to tell everyone we're giving you permission. Mm-hmm. But it was also pretty clear they wanted Osama bin Laden out of there. That was very different than going in going to get Maduro on a drug rap while you give a pardon to another drug lord. It was, I'm trying to figure out who's the good drug lord and who's the bad drug lord in this. But once again, I don't know if the president of the United States should unilaterally be able to go start a war with another country. And that's what's happening with Venezuela's weaker than we are. So, but if this had happened back in the Cold War days when they would have aligned with the Soviet Union, you could have had a nuclear war on that. Takes us back to the Cuban Missile Crisis and why Kennedy had to use so much restraint. One, he was a good president, but he also knew that if he didn't use restraint, we could have a nuclear war.
We had a question in the back there, and then I appreciate other hands for folks who want to jump in.
Very interesting presentation. I'm curious. I'm absolutely going to buy your book. It's going to be one of the best books I will have read since I retired. But I'm really interested in the role of money in our political system and how the Constitution deals with the potential of managing the expenditure of money in elections. It seems like arguably you can just spend whatever, but I can see some problems. Where does that get fixed?
Is your question?
Okay, Richard, we only have 20 minutes. Just go ahead.
Well, the question is whether the
In 5 words or less.
Are we looking at how the Constitution addresses this issue or how the Supreme Court thinks the Constitution addresses this issue? So, I think the constitutional understanding, we have First Amendment right for individuals, not the East India Company. The whole point of the American Revolution was the East India Company corrupted Parliament and persuaded them to, oh, there's going to be a tariff on everybody else's tea, except for our tea, you got to drink the tea. We toss the tea into Boston Harbor. That's the answer to that one. Money in politics, the contemporary role of money in politics resembles exactly the corrupt regime they had in Parliament we were rebelling against. And it's devastating. We discussed that in this book, what money has done to the political process. And I won't even talk about what Elon Musk could do to deliver the state of Pennsylvania to Donald Trump in the last election. They only stayed friends for about 5 months, but he literally did it.
Tom, you want to add anything?
Citizens United is the Supreme Court case you were talking about, and for those of you who don't follow this like we do, and thank heavens you don't, the Supreme Court for the second time, Buckley versus Mateo came first, said that money is speech. So Holmes's aphorism in his dissent in Abrams in 1919, the marketplace of diverse ideas, that's the First Amendment speech. Citizens United, this Supreme Court said, we're going to apply that, they affirmed an earlier case, Buckley, that money is speech. And Justice Kennedy went so far in that opinion to say, as Holmes talked about more speech is better speech, to knock down the bad speech, more money is better speech. And not drawing the distinction between human persons, citizens, people of the United States, individual rights, as the founders talked about it, versus businesses, corporations, and unions. We forget this was the unions too, are artificially constructed by state legislators to be actors in the commercial markets. So now we have a prohibition on regulation on expenditures in all of the campaigns because that's burdening or chilling speech as you make your contribution. The only exception there the court was willing to give, and then they narrowed the law to follow it, is if it's a traditional quid pro quo bribe. Senator, for this $100,000 or $240 million in a particular state for an election, we want you to pass this legislation. That is an illegal bribe. Same time, the Supreme Court turns around and says, by the way, if you give the money after the act, that's a gratuity, and that may not be illegal
Under state law.
Under state law.
Okay, so Professor Bednar had indicated that he'd like the microphone next. Professor Nick Bednar, we have our murderer's row of questioners here in the front who have expertise in this area.
Well, thank you very much for coming and talking about the book. And I give you kudos as someone who writes on presidential power for choosing to write about presidential power at this moment. I don't know how many law review articles I've thrown out in the last year. So related to that, I kind of wanted to hear a little bit more about the drafting of the book. You talked about how you get the page proofs back in June and decide to add 50 to 70 pages more. Was there anything, aside from just adding additional examples that maybe support your underlying theory, is there anything about the last year or so that changed your perspective of presidential power and caused you to rethink the theory you had set out to tell when you got this book contract in 2023?
Great question. Richard?
Not so much.
That was a real D move. You see that? Great question. Go.
I think this is a problem. This is not a problem unique to President Trump. This is a problem that's going to come up with future presidents. Indeed, my fear about the Trump versus United States case isn't what Donald Trump's going to do, it's what another president could do. Could be a president of the Democratic Party or the Republican Party. We have had a steady increase of presidential power. It can be used in all different ways. So, of course, there are many more examples that President Trump has given us in the first year of the second administration, maybe accomplishing more abuses than in the entire 4 years of the first Trump administration. Although what happened at the end on January 6th of 2021 was downright frightening, and we do discuss that. But this is a problem which is not going to go away by electing your favorite person, whoever it might be, to be president in 2028. It doesn't matter whether it's J.D. Vance or AOC. We are going to have this problem until we see the presidency differently. And our message is we need to see the presidency more in line with the way the founders did, with Congress as the preeminent branch, and with the president also listening to Congress and to the courts and to the people, and not think he has a mandate just because there's a majority in the Electoral College for whatever reason.
Mm-hmm.
I would just add that I don't think Richard or myself are naive particularly, but I think I'll speak from, I think I've been shocked in the last year. We had President Trump in the first session with lots of guardrails and advisors that was telling him no, 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 and sometimes he listened, sometimes he didn't. But to compare the two very different presidencies. And since January 20th, 25, we've seen in this year, State of the Union address tomorrow night, second one, we have seen the greatest number in any time frame like that of executive orders, completely overruling history in almost every single category. We've seen the largest number of injunctions, over 200 now, aligned with those executive orders. We've never seen such depth or volatility to presidential power, or perhaps overreach, or the burdening of our federal district courts. 24/7 now, writs of mandamus. They're up taking calls, making decisions, because people have been put in jail, rightly or wrongly, and a decision has to be made on them. We are overburdened with this stress and this disruption in the country. I don't think we ever thought we would see this. Mm-hmm. That's the surprise from Trump 1 to Trump 2. And we're just lucky that the book came out, right in the middle of this.
So we had the pleasure of recording a podcast with you earlier, Minnesota Law Now, available wherever you get your podcasts. That'll be coming up soon. And one thing you talked about this morning in relation to this was sort of the Justice Department itself and the way that has become different in this administration than in previous administrations. What are you seeing there, and did that surprise you as you started the book?
This is even worse than we've had in the first Trump administration under William Barr in particular. I thought there were enough problems that he needed to go, and I actually heard for his impeachment. Attorney General Sessions was better. He said, look, I'm not going to take your order to drop the Russia investigation and fire Robert Mueller. I'm your accused. And he kept getting tweeted at until he got fired. So it was rough in the first Trump administration. But this time around, it's been pretty clear that Attorney General, she's supposed to go prosecute the president's political enemies. Out here in Minnesota, where's the United States Attorney's Office? Is anyone there anymore? I mean, a bunch of people quit. They're told they need to focus on prosecuting Don Lemon for interrupting a church service, and they've all been pulled off the fraud cases. I mean, they had a serious investigation of fraud here in this state. In the U.S. Attorney's Office, they were doing a good job, nailing a bunch of fraudsters, and now people are quitting because they can't work for this Attorney General, because the United States Attorney here has been told to take orders from the Attorney General, who's taken orders from the White House. This is no way to run a Justice Department. I think it's a complete disaster.
I would also add that I'm old enough that I was, out of a federal clerkship, I went to the United States Department of Justice, Main Justice, as we probably call it. I'm an alum in the Jerry Ford administration. And our Attorney General was Ed Levy, former dean at the University of Chicago Law School, former president of the university, brought in specifically by President Ford on the recommendation of Justice Stevens from Chicago. They knew each other. And that's when the Watergate reform started. And I was a justice at that time doing political corruption and corporate corruption cases. And to go back and to remember those days, Watergate reforms, Ed Levy running a very clean, honest, totally ethical cleanup at the Department of Justice, and to see it today,
We have time for one or two more questions from the audience. I don't see hands right now. There's Professor Kirtley. Go ahead. Professor Jane Kirtley from the Hubbard School.
Hi, Jane.
Hi, Tom. Good to see you. Bill probably thinks I'm going to ask a question about the First Amendment, but I'm going to do it kind of obliquely. You've talked a lot about potential checks, balances, looking forward to future elections, power of the federal judiciary. But I'd like to ask you, because I haven't read your book yet, what about what I think of as the really uniquely Trumpian attacks on non-governmental institutions that we're kind of reeling under? Because while the individual's power at the ballot box is certainly important, if there aren't lawyers out there to bring these cases you were talking about, if the universities do not stand up to pressure from the Trump administration, I think we're lost. I really do. And the press. I number among those the people that I defend all the time, but the press is not standing up in the way that it should. So I'm wondering how much the non-governmental institutions figure into your book, and whether you think there's any salvation to be found there if the branches of government are found wanting.
Thank you, Jane. I must confess a conflict of interest here. Jane has mentioned a book I wrote with Lynn Niehoff from the University of Michigan on the First Amendment speech. And she very kindly gave a lovely review of it, so thank you. But, so conflict of interest aside.
Very, very ethical. Very, very ethical disclosure. I commend you.
I'm aghast because, as you well know, as a First Amendment scholar and a great journalist yourself, what we're seeing in these restrictions, whether it's DEI, whether it's impounding of research funds because we don't like it going to here or there, these are blatantly, per se, unconstitutional as content or viewpoint discrimination. The government cannot engage in viewpoint discrimination that burdens or chills or restricts speech, period. And that's why so much of this litigation is going forward and has to go forward. If we don't have our federal district courts to hear these claims, in my view, all of those First Amendment claims, right of speech, right of press, right of assembly, right of association, all of them are against this administration. And the First Amendment is clear about that, particularly this Supreme Court on free speech and free press. If it's content identifying what you can't do, DEI, books in libraries, or even viewpoint where they get more specific, that is per se unconstitutional, and this Supreme Court, I believe, will absolutely say that under all their jurisprudence.
Mm-hmm. Absolutely. I think that standing up for the First Amendment is critically important for lawyers in the bar. They've lost the cases against law firms, several, Perkins Coie, some others. I think the judges coming to the defense of the bar against punitive measures, taking away people's security clearances. When the universities have chosen to litigate, it's very hard. Harvard can do it, $55 billion endowment. And I guess their view is if Harvard was around to stick up to King George, they can stick up to King Donald Trump. It may cost them a couple of billion out of that endowment, but I think they're going to win if they fight it. I think we have to encourage everyone to fight, push back. Our churches, our universities, our newspapers. I mean, that's a big problem. See what's happening in the Washington Post. In the first Trump administration, Jeff Bezos was being threatened, Amazon was being threatened, and apparently Jeff Bezos decided that the bottom line is the priority. And so we see the Melania movie, we see the newsroom being fired. This all gets back to the so-called shareholder wealth maximization and corporate governance, which I think is a bunch of hooey. I teach corporate law. The only idea is to make money. Well, not if you're running a newspaper or CBS News. It's not just about making money in some law and economics theory of shareholder wealth maximization. What they're doing to CBS News is an atrocity.
Bill also introduced me as an antitrust lawyer and antitrust scholar, which I've been doing for a long time. So much of this has to do, your point about ABC, CBS, Paramount, et cetera, all has to do with potential mergers and joint ventures over here. And if we don't kowtow to this and recede, we will not get immunity decision, Article 2, he has all the power, antitrust enforcement, et cetera, to stop the mergers. So these are business decisions that are being made in contradiction of good journalism and contradiction of First Amendment. It's a business decision. We make more money if we can get the merger through. This is peanuts over here.
All right, well, we're just about out of time, but I'm going to ask one last question for a brief response from each of you. We've talked a lot about the past, a little bit about the present. Tom, you've talked about a lot of ways that existing institutional structures could be responsive to what you see as an excess of presidential power in the arc of history. What's the one thing that you would change about our structures right now to improve the ability to recalibrate presidential power the way your book thinks it should be? What would you change?
I think, well, the list is long.
Right, just one.
I think, back to our point earlier, I think Congress's oversight and legislation, and I think there maybe is an opportunity with the tariff decision and the reversal of the president's tariff position. I think there's a door that could be opened for Congress to seriously look at how do we define national emergencies, national security, war powers, how do we really define that, our responsibility to declare, his responsibility to implement. We've got to get that clear. Now, maybe a statute will not be sufficient. Maybe we need an amendment, which is near impossible. But we have to have a serious conversation, and I think that starts, because these are the justifications for everything, national emergency. Let's get a collective agreement in our Congress among our people. What's a real emergency? 9/11, yeah, we understand that.
Right.
World War II, Pearl Harbor, yes, we understand that.
Right.
These other examples.
Right. And I suppose in a Youngstown world, that helps move more things to the category where Congress has spoken.
Yes, absolutely.
Two
Richard?
things we need to get rid of are, one, immunity of the president from criminal prosecution for official acts. The founders never would have accepted that. And the idea that the president can't be prosecuted even after leaving office for criminal acts committed. So the Supreme Court's wrong on that. If they won't turn around on that, I think we do need to talk about a constitutional amendment. The second is money in politics and the Citizens United opinion. It's been a complete disaster to say the Congress can't even try to regulate the role of dark money in politics. A lot of it's not even discussed. That's why we call it dark money. I think the Constitution could be amended. Yes, it takes a long time to pass amendments, but times change. The minute there's a Democrat in there, all the Trump, abuse of presidential power. And oh, by the way, I'm one of the very few critics of President Trump who held Biden's feet to the fire for his unconstitutional student loan plan, for his classified documents held by the University of Pennsylvania. The people of Penn don't talk to me about that, nor the Biden White House, and various other abuses of power. Nowhere near as bad as President Trump. But we need people to stand up to presidential abuse of power in both Democratic and Republican administrations. And if we pass an amendment, it might take a while to get through the 3/4 of the states. But the minute there's a president in there that they don't like down in Alabama, oh yeah, we need that amendment. So I think we ought to explore that avenue.
All right. Well, please, everyone, join me in thanking both Tom Sullivan and Richard Painter.
Thank you. Thank you.